Hello, this is Steve Carlson, the 2012 nominee for the U.S. House of Representatives against Betty McCall. And I want you to know that in addition to the conduct of Mark Ritchie and the Democrats in the 2012 election, which I have brought before the Minnesota Supreme Court and the Federal District Court of the District of Minnesota, I want to tell you a little story about what the state of Minnesota and its faceless bureaucrats and political leaders do to a person who dares to run against them and to criticize their policies. This is what they did to me. And this is before the 8th Circuit Court of Appeals. This is what I'm putting in my appeal brief, my appellant brief there. I think it's important. I hope you look at it. There was no prior judicial review of the denial of EOC benefits in either STUI account, except for the two appeals as of right, defined and required by Minnesota Statutes 268.10 judicial review of the two ULJ unemployment law judge proceeding, each of which inexplicably concluded that the EOC statutes, quote, do not apply to Carlson, unquote, apparently meaning that Deed somehow concluded that I established each STUI account outside of the effective period of the new statute, which became effective July 22nd, 2010. This is impossible since I established these new accounts long after the new statute became effective on September 10th, 2010, nearly 2 months after, and December 5th, 2010, more than 4 months after. And so the statute applied to me in every sense of the word. And appellees compare my situation to Vogue versus Department of Employment and Economic Development, 794 Northwest 2nd, 662 from the Minnesota Court of Appeals, 2011, which Deed concluded a similar state statute requiring maintenance of 80% of weekly benefits when a new account was established and an applicant remained entitled to certain benefits did not apply to Vogue. But in that case, Vogue had already opened his new account 5 months prior to the date the new state statute became effective. In this case, I established my new account in question in Carlson 1, A11-254, nearly 2 months after the federal statute became effective. So there's no comparison. I did take appeal from the denial of each of these EUC accounts, but they were not the same because one involved payments from September 10th, 2010 to December 5th, 2010, and the other involved payments from December 5th, 2010 to December 5th, 2011. There were no payments for the first period and much reduced payments in the second because of the deprivation of the weekly benefit I had received through August 28, 2010, when the previous benefit year's account expired. The course of proceedings required for me to challenge this administrative decision was, for each period, to have a fact-finding, non-adversarial hearing directly with the ULJ on the phone, then to ask the same ULJ to reconsider their action, and then to appeal to the Minnesota Court of Appeals by the statutory process. This process, set out in Minnesota Statute 268.105, provides A. The Minnesota Court of Appeals must, by writ of certiorari to the Department, review the unemployment law judge's decision, provided a petition for the writ is filed with the court and a copy is served upon the unemployment law judge or the commissioner and any other party involved within 30 calendar days of the sending of the unemployment law judge's order under subdivision 2. There was no pre-deprivation notice or opportunity to be heard, and appellees have never contended that there was. In the first ULJ hearing, held about a month after the payments ended, the ULJ, saying he would not review the deprivation action but instead make a de novo finding of whether I was supposed to continue receiving the same weekly benefit amount of $293, refused to allow me to provide for the record the federal statute from 2008 that Valerie Woods, the Deed Appeals Specialist, cited that required her, she said, to deny me the payments. He refused to identify the basis for the denial and deprivation of the payments. He said he could not give me an explanation of the action and that he had no constitutional authority, that is to say, to review whether my constitutional rights had been violated. In his ruling, he said only that the July 22, 2010 federal statute, which extended the payments to me as set out in the complaint at paragraphs 8 to 10, purportedly did not apply to me. This pretense has been repeated through all my attempts to secure payment and other remedies for this conduct by appellees. And so this remains the basic question in this case. Does the law apply to me if my accounts were opened in the effective period? And related, why weren't required procedural protections under the Constitution and the federal laws and even state laws followed? No answers at all have been given by any court. In A11-254, appellees failed to file a timely brief, but the time was extended. And then they filed a late brief saying the question was quote-unquote moot because I had closed the account. And as the Court of Appeals recounts it in their order and opinion, quote, Deed contends that this appeal is moot. Order and opinion by Chief Judge Matthew Johnson, quote, Deed contends that this appeal is moot because even if this court reversed the ULJ's decision, Carlson would be unable to benefit or obtain relief because, quote, the original account that was the subject of this appeal no longer exists. Carlson cannot receive any payment from it, unquote. Instead, Deed asserts that any benefits Carlson receives can only come from the December 2010 account and would be payable for periods after the effective date of that account. And that was the opinion of Chief Judge Johnson. But Chief Judge Matthew Johnson ruled that the statutes governing review, Minnesota Statutes 268-105, judicial review, would not allow such a ruling because it required review. Nonetheless, appellees persisted, ignoring the Chief Judge's ruling, and they found a more favorable judge, Stoneburner, whose ruling on December 23, 2012 is that the case was moot. That was improper because it directly contradicted the panel that adjudicated that very issue, consisting of Chief Judge Johnson and Judges Wilhelmina Wright, now on the Minnesota Supreme Court, and Judge Stauber, with no chance for me to challenge or argue her arbitrary and unlawful decision. And she said the constitutional questions regarding procedure were irrelevant because she thought the plain meaning of the law denying me the benefits was so clear that the statute didn't apply to me. The order from Chief Judge Johnson is included in the record. It denies appellee's argument for mootness, saying, quote, a determination or amended determination of eligibility or ineligibility issued under section Minnesota Statutes 268.101 that was sent before the withdrawal of the benefit account remains in effect and is not voided by the withdrawal of the benefit account. Therefore, it's not moot, but this has been treated as moot because appellees, Governor Dayton, Lori Swanson, and the other individuals are attempting to bury this and then to exclude me forever from the federal courts. In other words, appellees went to extraordinary lengths, even defying the Chief Judge of the Minnesota Court of Appeals, disrespecting the final decisions of Minnesota courts to bury this and continue to injure me by cutting off benefits because of quote-unquote mootness, when that was not allowed by the law. And Judge Stoneburner violated the law of the case and state laws explained by Chief Judge Johnson because she is a judge and she can do that. Now, although I did pursue the same required channels for the second account, the December 10th one that resulted in a second Minnesota Court of Appeals ruling that merely cited Stoneburger's unlawful, unconstitutional opinion. And as such, it merely clutters the record, in no way constitutes relitigation. For as the Chief Judge said, this is review of a, quote, determination or amended determination of eligibility or ineligibility issued under Minnesota Statutes 268.01, a totally separate proceeding required by law. About 1 month later, I filed the adversary proceeding to force the turnover of funds to the estate and an accounting, including why they hadn't been turned over already. This deprivation, plus other circumstances involving appellees, forced me into bankruptcy as my primary residence was about to be sold at sheriff's auction. Appellees forced me to continue working, if I was medically able, for $35 weekly for hard work of 15 hours per weekend, or they would terminate all benefits, which I wasn't receiving since my benefits were determined to be $0 payment. Appellant listed the claim for payment of these funds plus some damages as an exempt property on my bankruptcy forms, filed the adversary proceeding to turn them over. The adversary proceeding was transferred to the district court, who assigned it to Magistrate Keyes. He recommended the court abstain from the entire matter under the Younger Doctrine, dismiss the entire case. The recommendation was accepted and the final judgment entered December 5, 2012. Although the district court did not discuss any of the bankruptcy issues and even denied it exercised bankruptcy jurisdiction after the transfer, it dismissed the entire case with prejudice and finality. The district court then went on to bar me forever from the protection of the federal courts in Minnesota as a, quote, danger to the federal courts, unquote. This, I contend, is uncivilized and not in accord with our cherished American constitutional rights. In addition, the magistrate has used this case as the basis for barring appellant from filing any federal cases myself, including even bankruptcy claims. His reasoning was that in the case under review in the instant appeal, Carlson asserted claims that were barred by the doctrine of res judicata, citing document 35 at 3 to 5, 14 to 15. Document 35 is the report recommendation, discussing overlap between Carlson's earlier state court lawsuits relating to his eligibility for certain unemployment benefits and the claims he sought to relitigate in federal court, and concluding that the federal lawsuit was barred by res judicata. This court recently recommended dismissal of those claims because Carlson litigated and lost the same issues he raised in the transferred case, unquote. The district court leads off with this case in justifying a permanent ban on my access to the federal courts. The statement of the case now, beginning with the nature of the case. This case was begun in the bankruptcy court as an adversary proceeding, complaint paragraphs 1 to 3, and transferred to the district court because it contained Article 3 claims with related to jurisdiction. The state brought a motion for judgment on the pleadings in the district court on the basis that because the case had been transferred based on related to jurisdiction, the district court bankruptcy jurisdiction of the case and jurisdiction over bankruptcy claims, that the claims were barred by the 11th Amendment, res judicata, and collateral estoppel, and that the Younger Doctrine required abstention. Instead of carrying out its bankruptcy duties, the magistrate dismissed all the claims as the state presented them and as he accepted them.